Welcome to the Appellate Division First Department 2.0. I hope everyone is having a great day. We'll begin with a call of the calendar. People versus Luis Martinez Vasquez is submitted. Papas versus Moody's Investor Service. Appellant is awarded 5 minutes and 1 in rebuttal. Respondent Moody gets 5 minutes. G. Children is submitted. Nestenberg versus Standard International. Appellate Standard gets 5 and 1. Respondent gets 5. U.S. Bank versus Maruriello is submitted. High Hung Constructions VNAB 2000. Appellant gets 6 minutes and 1 in rebuttal. Respondent gets 6 minutes. People versus Johnson is submitted. Mayers versus Becker and Polyakov. Appellant Becker gets 5 minutes and 1 in rebuttal. Respondent gets 5. Calere versus Fagerman. Fagerman gets 5 minutes and 1 in rebuttal. Calere gets 5 minutes. Endolix V versus Vaso Medical. Endodelix gets 6 minutes and 1 in rebuttal. Respondents Vaso Medical gets 6 minutes. People versus Juan Felix. Appellant Felix gets 4 and 1. The people get 4 minutes. Wells Fargo versus Min. Wells Fargo gets 5 and 1 in rebuttal. Respondent Min gets 5 minutes. Rosengarten versus New York State Office of Children, City and State Office of Children. The petitioner, Rosengarten, gets 5 minutes and 1 in rebuttal. And then the New York State, both the city and state get 5 minutes each. Ochoa versus Algeria Operating is submitted. Castillo versus Victoria's Secret Stores is submitted. 10 East 53rd Street owner is submitted. And last, Board of Managers, Hunter 88 versus Red Apple Child is submitted. First case on the calendar is Papas versus Moody Investor Service. Okay, let me first hear counsel for Mr. Papas.
Yes, Your Honor. This is Pearl Zaklevsky.
Okay, you may proceed.
Thank you. We are asking the court today to reverse the decision of the court below, granting the defendant's motion to dismiss this case. And we're doing that because we believe that the rather brief opinion that was issued without any specific analysis is fundamentally flawed, both factually and legally, for 4 separate reasons.
What is, can you please tell me, counsel, what is Mr. Papas' protected class? I mean, I know that he talks about being a non-compliant male, but isn't that insufficient to show that he's a member of a protected class?
I don't think so. I think that's not quite correct, Your Honor. And the reason is gender protection does not mean that you have to be female, you have to be African American, or any particular category. What it means is that because of your gender, some action was taken against you that would not have been taken but for your gender. And here what we're saying is that a flawed sex harassment investigation was used against Mr. Pappas, and it was used against him only because he was male. So
Yeah, but
what is the
Pappas,
comparable
excuse me,
group?
this is Judge Friedman. But Pappas alleges that he complained about his supervisor's improper business practice related to issuance of credit ratings, not about discrimination. So how does that fall into the human rights law?
It falls into the human rights law because what we contend is that, and that you're absolutely right, Your Honor, we don't contest whatsoever that a complaint about business practices might fall under some other statutory protection, but not under the human rights law. What we're saying is that as a retaliatory action, what the employer did was use a proxy sex harassment investigation because Mr. Pappas was male in order to retaliate against him. It used his gender against him.
But are you saying that there were women that were accused of sex harassment that were basically allowed to harass with impunity and he wasn't because he's a male? Is that what you're saying?
No, not at all, Your Honor. This is not a case in which we're alleging that he was treated differently from females. What we're saying is that his gender was a vehicle by which the employer was allowed to take an adverse action against him.
So counsel, this is Judge Singh. You're arguing retaliation. Is that correct? That's what I'm hearing. That correct?
Yes, Your Honor.
So what protected activity was the plaintiff engaged in here?
Okay. We think that the court below misconstrued the present law on protected activity. Title VII and the EEOC guidance on Title VII, which, as you know, is a lower standard than our state's human rights statute and our city's human rights statute, says that protected activity includes any participation of any kind in a sex harassment investigation, including if someone protests his or her innocence in connection with that. So protected activity is much more broadly drawn than the court has found. He protested it in a few ways. He questioned the timeliness of it. He questioned how it was being conducted. He very much disputed the allegations against him. And as we pointed out,
Counsel, can you tell me, because I'm still quite nebulous, mostly because I don't see the facts that you have alleged. Well, he was treated differently because of his gender or his sex, or was treated less well. So if you go to the lower standard, which is disputable that the Title VII is a lower standard with respect to retaliation, but putting that aside, tell me, what is it that you are alleging that the employer did?
I will try my very best. And I admit that this is a bit of a twist, let's say, on the usual.
A twist or a stretch?
Both. But one of the things I think we should, as Judge Hochul said, we should be proud of our firearm regulations. I think we should be proud of our human rights legislation, which does stretch various conditions. And just to get back to it, this is not the usual case where what we're saying is that he was treated differently than women. What we're saying is that something adverse happened to him solely because his gender as a man. And
is that the case, or is it the case because there was a claim of harassment and there was an investigation and he is the subject of the investigation? It seems to me that you need more than that to be able to state a claim, no?
I think what we can show, well, if we're given the
you say it's unfair, for example, he disputes it, but traditionally we haven't considered that as a form of sexual harassment, right?
No, but if in fact he complains about the conduct of the investigation and then his employment is terminated, that certainly falls well within the scope of what the courts protect in discrimination cases. And I want you to know, I think my time is up, but of course, if you have any other questions.
It is. Thank you. You got a minute rebuttal, so let's hear from the respondent.
Good afternoon, Justices, and may it please the court. Ken Turnbull for Respondent Moody's Investors Services. The court properly dismissed each of the claims, and I'll take them in turn.
You know, the somewhat unsettling aspect of your position, of course, is that here you've got the plaintiff who got these in 2016, shortly before his discharge. He gets these really great ratings. They're laudatory ratings about what a great job he's doing.
Yes, Justice Friedman, he did. According to the complaint, he got positive reviews, and it shows that there was no retaliatory or discriminatory motive by Moody's in how it was treating him. After he got those positive reviews, a female colleague raised a sexual harassment allegation that Moody's undertook an investigation, as it was required to do. And as a result of that investigation, his employment
and then
was
he
terminated.
calls up the HR person who's in charge and says, what's happening with the investigation? And that day he gets fired.
Yes, Your Honor. So plaintiff has attempted to switch his claim from what by on its face was he opposed business practices that he thought were improper. That's the face of the complaint. There are 9 different paragraphs that say he was retaliated against because he opposed his manager. And in argument and on the briefing, he's now saying, I opposed the sex harassment investigation. But if you look at the allegations in the complaint, that quote unquote opposition consists of but 2 things. Number 1, he called and asked about the status and was informed that you'll be told once it's complete.
I suppose what he's saying is that you used that what you did is use a investigation into sexual misconduct as a pretense to discharge him, and that somehow violates the human rights law.
In fact, that's right. But what he does say is actually a little more specific. In paragraph 27 of the complaint, he claims that Moody's used this sex harassment investigation as an excuse to terminate him for what? Not because he's male, not for opposing a practice that's illegal under the human rights laws. They used it to terminate him as reprisal for resisting improper directives from his manager. So again, he's claiming that he's being retaliated
So why isn't that protected activity?
So
you have a right to complain if your manager is using alleged illegal activity of harassment as an excuse to otherwise harass him or affect his privileges and conditions of employment.
Right, but agreed, Your Honor. But again, the only questions he raised to Moody's were the 2 I referenced. What's the status of the investigation, and why am I seeing this human resources person around the premises? Those were the only 2 alleged opposition to the investigation.
But in fairness to him, I mean, he did cross move to amend the complaint and was denied, right?
The cross motion to amend was focused solely, the only amendments were focused on the tortious interference claim, not on the retaliation or discrimination.
So there was no clarifying, not that it needed to be clarified, because You know, but he didn't attempt to clarify his allegations with respect to retaliation, you're saying?
That's correct. There was not a single proposed amendment. I would like to say also that the assertion by Mr. Pappas that participation somehow constitutes protected activity because he was interviewed as part of the internal investigation does not constitute protected activity. The law is clear that an internal investigation, before there's been any EEOC charge or any filing in court, does not constitute protected activity, and that's the situation we have.
I don't know where that argument goes, but I suppose his best argument is that, well, he complained about the unethical things that his supervisor was allegedly doing in regard to ratings and in regard to two companies that were being merged. And to get back at him, in order to retaliate for those complaints, they used this investigation of sexual misconduct to fire him. Does he have protection for that sort of a claim under the human rights law?
You know, it's interesting. The alleged retaliatory action is motivated in that example by his opposition to his manager, as if I understood your hypothetical correct.
Right. Well, isn't that what he's saying?
Not motivated by protected activity under the human rights law. He didn't engage in any protected activity under the human rights law.
Okay. Thank you, counsel.
Thank you.
Okay, Appellant, you have 1 minute.
Thank you. I'm just going to read a quote from the Derivan case, which we cite in our reply brief. It's a case from the federal court discussing Title VII, which, as we say, has a lower standard. So if it applies to Title VII, it most certainly applies to our state statutes. The participation clause protects those who testify in an employment discrimination case about their own discriminatory conduct, even if such testimony is involuntary. We accordingly hold that defending oneself against charges of discrimination, to the extent that such defense involves participation in a Title VII proceeding or investigation, is protected activity. That's the Derivan case in our cited in our reply case brief. The other thing I just want to point out very quickly is that the court also dismissed the tortious interference claim, claiming that we did not provide evidence.
But he did get another job with Fitch. I mean, he says they stopped returning his calls, and I don't know what facts he has to back that up. He doesn't really seem to have any, but he did get another job, and then Fitch dismisses him.
But
how is that Moody's responsibility?
Because what we're alleging is that while he was at Fitch, one of his Fitch coworkers said that she had heard that he'd been involved in sex harassment complaint. That should not have happened if, in fact, Moody's had complied with its confidentiality.
Isn't that too speculative? Isn't that too speculative to build your course of action on?
It might be speculative at this stage, in a pleading stage, Your Honor, but, you know, as your court has repeatedly said, all inferences should be drawn in favor of the plaintiff.
Okay. Thank you, counsel.
Bless you, Judge Kavanaugh.
Thank you. Sorry.
And thank you very much, Your Honors.
Thank you both. Next case on the calendar, Nestenberg versus Standard International.
Good afternoon, Judge.
Good afternoon.
May it please the court, Anthony Yourself for the appellant. In this case, Judge, we make the argument, quite frankly, that a prima facie case was made entitling us to an award of summary judgment.
I'm sorry. Could you point to the evidence that of when the sink was last inspected, which, as you know, is sort of the precedent in this department? You need to indicate that as part of your prima facie case.
Sure, Judge. On page 696 of the record, it's volume 2, the director of engineering testified that this sink in this hotel room just like any other sink in any other hotel room, was the subject of what amounts to be daily inspections by housekeeping staff. Guests cycle through this room daily, as does the housekeeping staff to clean up after those guests on a daily basis. The procedure.
Was that procedure? I'm sorry. Go ahead, Bahati. I'm sorry.
Well, I just want to know if the witness or the person who presented that evidence, was he present in 2014 when this incident occurred?
He was not. He was not, Judge. He was not. But he's
So
he's
does he
familiar.
possess the requisite knowledge to attest to such notice?
The point that I'd like to make to that, Judge, is that he possesses the knowledge that everybody has of every hotel bathroom.
So in other words, it's custom and practice. Is that what you're arguing?
It's absolutely custom and
But
practice.
is under our case law, is custom and practice sufficient? Don't you? We've looked for logs. We've looked for other sort of indicia, in fact, to show that these inspections take place, right?
Judge, I can appreciate the fact that that you'd look for a log. The fact of the matter is, housekeeping
or
staff.
a person with personal knowledge, as my colleague was saying, who actually did the inspection. Somebody from housekeeping. For 10 years, I've been doing inspections of all the bathrooms or sinks or whatever it is.
Hansel, it's to add to that, it sounds like you're suggesting that the housekeeping staff is making inspections of the sink. I don't really, I thought that the testimony was from an engineer. I mean, I don't really think that the housekeeping staff is qualified to, I mean, if the sink was off the wall, I think the housekeeping staff would have announced that, but I don't think they're the ones that are checking it out for any kind of structural soundness.
To that point, Judge, the housekeeping staff, the testimonies is the eyes and the ears of the engineering department. So when you have a housekeeper in a bathroom every single day wiping down a sink, if this sink was in such a decrepit state, such as the one that's described, that it would spontaneously fall free from a carrier-mounted wall system, that's something that we would have seen and observed well before this accident took place. And the daily
I know that you don't quite.
You would have seen it every 63 days, right? That's what Mr. Gunaratne basically testified, that's the span of time in which he conducts maintenance check of each guest room at the hotel. But when he was asked directly whether the procedure was in place in 2014 when the accident occurred, he said he did not know if that was the procedure.
The procedure you're speaking to, Judge, is what he called a care, which is when an engineer goes into the room and checks it top to bottom. The custom and practice that we're asserting is more from a housekeeping perspective that goes on a daily basis in every hotel room in Manhattan.
I see. While you sort of make a fleeting reference to the duty question, you accept that you do have a duty to be inspecting whether the sink is affixed to the wall properly on a constant basis. You don't take the position, well, a hotel doesn't on a regular basis go around inspecting whether, having not heard any complaints from anyone, whether a hotel has an obligation to on its own go into the hotel rooms and check whether the bathroom sink remains affixed to the wall.
I think, Judge Friedman, it's a question of reasonableness. So in this case, this specific sink was affixed to the wall on a carrier-mounted bracket system that's inside the wall. So the extent of our obligation, of our duty to inspect is a reasonable one. We don't have an obligation to go in and make a hole in the wall to see if it's structurally sound. We have an obligation to go into the room, to wipe down the sink, to realize if it's so loose to the point where it's going to fall off a wall and crack into 1,000 pieces, that we should observe. But that duty doesn't go to the level that plaintiffs would have it go, which is to make a.
I mean, just in terms of the legal status with this is in, we denied summary judgment to JES Plumbing, so it's sort of hard to see how you could get summary judgment. I mean, I know the cases are not identical, but it's quite a burden for you to overcome in the face of that JES decision.
that decision was made absent any kind of an engineering predicate on behalf of the movement, which something I presented to the court, Judge.
And I'm sorry, I'm lost here.
I don't think that's true. I was on that bench and I have a copy of the decision, and we did have an expert affidavit from an engineer in that case.
Judge, the expert affidavit in that case assumed mistakenly that weight was applied to the sink prior to its collapse, which is not what the plaintiff testified. The plaintiff testified.
Thank you, Mr. Orcel. You're way over the time. Let me hear from the respondent in this case.
Good afternoon, Justices. Christopher Jocelyn for the respondent, Carl Nestenborg. I think what this court has to address as a threshold matter is whether the appellant in the lower court proceedings met its initial burden with respect to the granting of summary judgment. I think Your Honors have touched upon that with respect to constructive notice, in that there's nothing in the record to indicate when the subject sink was inspected. The testimony that was offered by the defendants.
It is the idea that a hotel has an obligation to send around inspectors to check that sinks that were installed when the property was built. And I don't believe this was the work, and this was done so long ago, that they've got on a regular basis send someone around to see whether the sink is still attached to the wall.
This particular sink is unique in the sense that it's a sink that's mounted directly into the wall, rather than having some support system underneath it. And because of accumulation of humidity and moisture within the environment in which that sink is in,
I think everyone realizes that may not be typical, but it's not unusual. There are many times that bathroom sinks do not necessarily have legs underneath the sink holding them up, and that's attached just to the wall.
I agree with you,
because
Your
it's
Honor.
attached to the wall, you mean they have to, on a regular basis, send someone around? Is the sink still attached to the wall? Not having heard any complaints from anyone and being given any indication that there's any problem with that sink.
And I think, to answer your question, we have the testimony of the director of engineering in this case, who was not the engineer at the time of the accident, but became the engineer, and he implemented an inspection procedure every 63 days to ensure that there were no issues with the way the sink was mounted to the wall. So I think they do recognize that there is a duty to inspect it, but as it relates to the issues before this court,
I recognize. I'm not saying I've concluded that there's no duty. Don't misunderstand. I'm probing. I understand that there's a duty as a room changes from one customer to another customer, that there's some sort of a duty on the hotel to check that room, which has been a common practice. Housekeeper goes in, linen is changed, towels are changed, etc. But is there also a duty, not having heard anything, to send someone in to check whether the sink remains attached to the wall? I mean, do you check whether the light fixtures are still attached to the ceiling? You don't say that you have to go in and check that, do you? Why is that different? Maybe the fixture is falling down.
I think
in the ordinary course of events, a sink which has been installed properly doesn't come off the wall unless there's something done about the sink which wasn't supposed to be done.
And I think that it addresses a bigger concern in this particular case, and that is the failure of the appellants to meet their initial burden, demonstrating that the sink was properly installed in the first place. And that gets to this court's holding in the third-party case, in which this court determined that there was questions of fact as to whether or not the subject sink was properly installed. Here, like in the prior case, we have an expert engineer who opined that if there was less than 250 pounds of force applied to the sink and the sink collapses, one can conclude that it was improperly installed or defective. In this case, the lower court properly determined that the defendants, the appellants, failed to establish that the sink was properly installed in the first place. And accordingly, they didn't meet their burden entitling them to summary
Counsel,
judgment.
Judge Singh, what do you make of the defendant's expert who opines that downward pressure in excess of 400 pounds was placed on the sink? Does that raise an issue of fact, essentially, as to whether the plaintiff somehow was responsible, or whether, in fact, it's a cause and create, there was a defective installation of the sink?
I think it creates the classic question of fact. Vincent Attari, the expert that was retained by the defendants in this case, opines that there was more than 250 pounds of pressure. In fact, it was in excess of 400 pounds. And if the jury was to accept Mr. Attari's opinion, then the jury can conclude that it was properly installed and that it was not the responsibility or the fault of the
Your client,
defendant.
after all, doesn't really give a clear picture of how this happened. He had many drinks and probably was not sober. And he doesn't really say, he says he's on his feet as this happens, and he doesn't quite say he leaned on the sink. He doesn't really give a picture of just how this happened.
I think he did, Your Honor, that he said he was leaning against the sink. He was talking to his friend Axel, who was also in the bathroom.
But then he says he was firmly planted on his feet.
But that he was on his feet, leaning against the sink. And you know, as it was pointed out, I believe this creates a classic question of fact as to
how much does your client weigh?
187 pounds.
That's what I recall.
At the time of the,
even if he was leaning against the sink, it shouldn't have come off the wall because it should be able to take more pressure, correct?
Right, it would even be less pressure than 187, I would think, if some of that weight is being placed on his feet. It should have been able to withstand him actually sitting on the sink if you accept that he was 187 pounds at the time of the accident.
Okay, thank you, Mr. Jocelyn. You get 1
Thank
minute,
you, Your Honor.
Mr. Also.
Judge Singh, just to your point about weight, the testimony, and I would encourage the court to really focus in on the affidavit of Vincent Attari, the engineer. From a physics perspective alone, if both of his feet are planted firmly on the ground, which is what he said, you wouldn't have any load on the sink itself. And that's the key issue that distinguishes.
So you're suggesting, counsel, that the accident occurred in some different fashion, right? That's what you're suggesting. And isn't that really a classic issue for the jury to decide as to how the accident occurred? Because I imagine there are scenarios where the sink could have fallen, which are not consistent with maybe how plaintiff says the accident occurred, right?
We're suggesting more than that, Judge. It's a suggestion that physically this could not have happened the way it's been.
Well, it may have happened differently than Mr. Attari suggests, right? Because he suggests that, that too much greater load either through his own activity, that is the plaintiff's own activity, the combined weight of more than one person, or movement activity. That's quintessential jury judging, no? I mean, you want the court to determine as a matter of fact how many people were on the sink, who was leaning against it, basically in light of what plaintiff is alleging, that has to be accepted as true for these purposes.
The engineer's suggestion is that plaintiff's version of events is not credible as a matter of law.
But that's a good argument to the jury, not to us, right? Thank you
The
both.
question is whether we can decide this as a matter of law.
Understood.
Thank you both.
Thank you, Your Honors. Be well.
Thank you.
High Hung Construction.
Sure. Good afternoon. May it please the court. Michael Cassell for the defendant appellate NAB 2000 Realty. In this matter, the lower court, upon NAB's motion for summary judgment, searched the record and granted summary judgment to the plaintiff, High Hung Construction. The lower court also directed NAB to sign over a check that NAB and High Hung received from NAB's insurance company, Seneca Insurance Company, for almost $218,000.
Is there an inconsistency between finding issues of fact on one hand and granting summary judgment to the plaintiff on the other?
In this case, definitely. I mean, the
What's
facts.
the inconsistency here?
Sure, the court found basically that there were issues of fact, found that plaintiff couldn't sustain its burden and, sorry, defendant couldn't sustain its burden in demonstrating issues about whether or not Haihang actually completed what it was tasked to do under the contract. In support of its motion, in support of defendant's motion, NAB's motion, we relied upon the affidavit, the documents from the architect for land. He set forth the numerous DOB violations. The court somehow found that those violations didn't show that Haihang failed to complete its work, but clearly there's a question of fact there, that Haihang is brought in to do work and to satisfy the DOB. We have an affidavit from NAB's architect that says that there were DOB violations that were issued afterwards, and DOB violations that pertain specifically to what Haihang was supposed to do, which is
Did you get any invoices that explain the work that Haihang allegedly claims that it did that would have led it to be entitled to something like $218,000 or the entire amount of the insurance check?
The entire basis for its claim is on page 44 and 45 of the record. It's the most meager invoice I've ever seen. I know the court can't take judicial notice of this. I once had a fire and I've seen what insurance companies require. It should be page after page and after page of details before an insurance company will issue a check as to what a contractor does at a site. The invoice itself doesn't even include work for the basement and first floor, notwithstanding this timeline that was submitted. So
you suggested, Mr. Cassell, that Seneca issue a $200,000 plus check without ascertaining whether in fact the work had been done?
Correct.
That's the first time that I've ever seen an insurance company doing that.
Well, it happened here because the building was so underinsured. The plaintiff itself represents that the building was substantially underinsured. It's an entire building that has $1.5 million in insurance coverage. So the insurance company knew it was going to pay $1.5 million. And in fact, the remaining balance to my client says—
Well, if it was underinsured, there wasn't a co-insurance issue?
I'm sorry, what?
You say it was grossly underinsured, right? If it was so underinsured, why were they paying the policy? Wouldn't there be a co-insurance issue?
I'm not aware of a co-insurance issue. The insurance company would have looked at the damage and realized that it far exceeded $1.5 million. The plaintiff itself—
Usually in insurance, if you don't insure your property for enough money, don't you become a co-insurer with the insurance company? So that if your property is worth $2 million and you insure for $1 million and you have $1 million in damage, they're only going to pay you $500,000 to really simplify the concept. If you say it was so grossly underinsured, why wasn't that a factor here?
I've never dealt with that exact concept. What I see here is a building that the damage far exceeded $1.5 million. And to be clear, this is not just me saying that. This is actually in plaintiff's own papers. They say the building was—
But your agreement did contemplate with the plaintiff that you were going to turn over to them what the insurance company paid. What were you expecting to happen with that agreement?
The agreement says that the plaintiff is entitled to be paid through the insurance company, but case law from this court and numerous other courts say in this scenario, the party which is seeking summary judgment here, which is essentially the plaintiff, must demonstrate as a matter of law that the contractor fully and satisfactorily performed with the contract, which has not been established, number one. And number two, we cite numerous cases from this court that says the mere fact that a third party issued a check is not proof positive that the work was completed. In this scenario, in order for Haihang to obtain summary judgment, it had to demonstrate as a matter of law that it fully and satisfactorily complied with the contract. It doesn't come close to doing it. In fact, it admits in its own papers that there are material disputed issues.
So when your agreement says, and this is what your agreement with the contractor was, we agree that the cost to do this repair shall equal your insurance settlement on the emergency repair portion of your insurance settlement. What does that mean?
It means that Haihang would be paid by the insurance company. Certainly, Your Honor, that if there was a situation where Haihang did no work at all and submitted a bill for $2 million, the mere fact that they're paid by the insurance company becomes irrelevant. Clearly, in this situation, the insured NAB has the ability to challenge what the bill was from Haihong, especially since every single dollar paid to Haihong was one less dollar paid to my client. So the mere fact that Haihong was paid from the insurance company doesn't give it a blank check to do no work at all and then try to seek hundreds of thousands of dollars from the insurance company, which is essentially what happened here. It has an invoice which has no details. They have no documents, not a single document to support its work, and they're claiming $218,000. We simply argue there's a question of fact. The jury should determine how much Haihong's entitled to.
Thank you, Mr. Cassell. Let me hear from the respondent. And
Thank you.
Can we let in Mr. Harron from the lobby, please? Go ahead.
Thank you. May it please the court, my name is Craig Blumberg. I represent the plaintiff respondent. I think the court hit on a couple of very important aspects of this case, and that is the plaintiff performed the emergency mitigation services in accordance with the contract that does specifically
How did you establish that, counsel?
Establish what?
How did you establish the premise that you're arguing now, that in fact you did the work? How was that established?
Well, two reasons. Number one, we submitted the invoice that shows that, but number two, and most importantly, as the court stated, Seneca would never make payment. No insurance company would make payment naming anybody else on a check unless they inspected and confirmed.
So is it your position based on the check alone that Seneca inspected the building?
Well, we know they inspected the building, and the lower court found that the plaintiff, in opposition to our argument that the building was inspected, was unable in any way to show that the building, that was an untrue statement. Because
was there any proof of the inspection? And then also in regards to the invoice, was it detailed specifically as to when the work was done and how much it cost to do this particular type of work? Or was it just like a general invoice? This is what we did.
It was a general invoice, but that's what's submitted, and there's nothing wrong with an invoice like that. Just because the invoice isn't detailed doesn't mean that the work wasn't done, and there's no evidence that the work in fact wasn't done. And the fact that Seneca paid that in and of itself confirms
but let's
that the work was done.
You making the payment or the issuance of the check travel a great distance, and that's a concern that I have. Do you think that NAB has no responsibilities at all to inquire about the nature of the work that was done? I mean, they still own the building, right?
Well, I don't know that they still own the building.
What happened to the building when this was finished?
What happened was, and getting back to the issue of how much insurance, this is all an issue because the building owner was so underinsured that they didn't have enough money with the insurance that was paid for the damages to do the repairs.
No, but that's clear, counsel. The concern that I have is that once the agreement is made and there's an agreement that basically the contractor will accept any money that's paid by Seneca, does that mean then that the owner has, although not the one paying, is the insurance company paying, the owner has no responsibilities to check whether the work was proper, whether the nature of the work was actually performed? You think that that's just an insurance company function, not an owner function?
No, what I'm saying is, as this work was being done, the owner was fully aware of it and acknowledged that the work was being done. And it wasn't until after they realized they were so underinsured when the owners took it upon themselves to perform work without a permit that the building had to be demolished. They're using this as a way to get more money to repair the building when they know that this mitigation work was done.
That's what's a little bit hard to understand with your position here. You mean there's $217,000 worth of work done on this, which one would think is quite a bit of work, and then at the end you decide to take down the building. How do those two things go together?
Because the insureds decided they wanted to take down the building, and locked the demolition, locked our company out of the building, and then proceeded
After they incurred $217,000 in
Yes.
in repair costs?
Yes, and there's the deposition testimony shows that after this work, in the middle of the work being done, the mitigation work being done, they locked the mitigation company, my client, out.
But they say that you indicated that the cost of this work was only $30,000 to the Department of Buildings indicates that the cost was only $30,000.
That is simply an amount that's put on by the person filing for the permit. That is no evidence whatsoever of what work ultimately has to be done. And
But
this
I
was
mean, Mr. Bloomberg, isn't that like an issue of fact? Because that's what was, that $30,000 was put on a document to the DOB. The invoice was very, did not include very much information as we would normally expect from an invoice. Because the insurance company paid, I don't think that's proof of anything. It's proof of something, but aren't all those facts taken together at least an issue of fact? And I know there was testimony from the defendants that raised a credibility issue, but again, all these factors put together seems to me to be an issue of fact that we may have to get to at a different time. You may ultimately be right, but
to respond to that, the lower court did find that there are issues of fact when it comes to how much defendant may owe plaintiff. The issue here is simply the fact that Seneca Insurance Company issued the check, and in accordance with the contract that was signed by both parties, we are entitled to that check. The case is still being litigated, and they may be able to recover money from us, but that's not the issue that that's being appealed here. The issue is simply that we had a contract. In accordance with the contract, the insurance company issued the check.
So in other words, counsel, to take it out logically, if in fact you did $10,000 worth of work and billed for $200,000 and Seneca paid the $200,000, the owner says, money's gone, nothing I can do about it. That's your position in effect, right?
Well, they are doing something about it because that will be.
But isn't that your position, that if you do no work or very little work, you're still entitled to whatever the insurance company gave you?
Not when there's evidence of the work being done confirmed by the insurance.
But that seems to me that it's disputed as to what you did, how much you did, including all the issues you raised with about being locked out of the job site, et cetera. It seems to me that those are all issues of fact for a fact finder to determine.
Well, I think that's what the lower court found, but when it comes to the sole issue of the fact that the check was issued in accordance with the contract to which the parties agreed, we're entitled to the check.
Thank you, Mr. Bloomberg.
Thank you.
Okay, you get 1 minute rebuttal.
Sure, 2 quick points. If I understood counsel correctly for the plaintiff, he just stated that his client was locked out in the middle of the mitigation work. If that's the case, the lower court found, this is on page 15 of the record, Seneca apparently inspected plaintiff's work and deemed it complete. So counsel just acknowledged that apparently it was locked out and couldn't complete the work. The lower court somehow found Seneca inspected the work and found it complete. Secondly, it's important to keep in mind that plaintiff never moved for summary judgment. Well, I understand the court can search the record, but plaintiff never moved. And essentially, by the court finding as a matter of law that Seneca completed the work, if plaintiff moved for summary judgment, at least defendant could have subpoenaed the records for Seneca, tried to get some information from Seneca. We don't even have the file from Seneca to find out the details as to why he issued the check. So we have issues of fact here all over the place. Summary judgment was not appropriate. Thank you.
Thank you, counsel. Mayors versus Becker and Polyakov.
Yes, good afternoon. Benjamin Oxenberg, Furman, Kornfeld, and Brennan for the appellant Becker and Polyakov. If it pleases the court, we're asking that the decision be reversed for both procedural and substantive reasons. I just want to briefly talk about the procedural reasons first, since respondent does devote a substantial amount of time talking about them. First, the order on appeal, Justice Feinman's order, was not a sua sponte order by definition because it resulted from a motion made on notice, and therefore it's appropriate appropriately appealable as of right under CPLR 5701A2. The Shoals Court of Appeals case makes this
So
clear.
it was based on a motion made by Becker, right?
Yes, that's correct.
Okay, so and upon notice.
Upon notice, yes.
Okay.
The issue is the court decided to deny the motion before.
Yeah, I won't spend too much time on that issue. You should
Okay.
go to the next issue.
Fair enough. The second procedural
Why
reason.
wasn't it premature, right? There was a motion made. Mayors could not respond because claiming that they did not have the documents in their possession in order to oppose the motion. So what do you say to that?
Well, Your Honor, under that logic, every CPLR 3211 motion would be premature. They all and.
But the problem is that discovery was not completed, right?
That's correct, but discovery is never completed when a movant chooses to make a pre-answer motion to dismiss. And subsequently, this court ordered essentially that discovery had taken place. So this respondent is in an even better position because he has documents now. He was permitted to file a supplemental record. And even considering all of that, he still does not have a claim for legal malpractice.
Okay, so why don't you address that? Why don't you address that issue? Why isn't a cause of action stated, namely that the defendant attorney was negligent with respect to advice on the settlement, and but for that negligence, plaintiff would not have sustained any damages? I know you make arguments, but those arguments seem to me are really more issues of fact related. Why isn't that claim sufficient?
Well, for a few reasons, Your Honor. First, the claim is impermissibly speculative under many cases from this court.
If the attorney had advised the plaintiff not to enter into this agreement because it could result in a potential suspension, maybe something different would have happened, no?
Well, what would have happened had he chosen to go to a hearing is that the Connecticut Department of Banking would have revoked his license, and that would have resulted in the exact same outcome. He would have been.
But isn't that speculative at this point? I'm sorry. Go ahead.
Isn't the issue here that the SEC specifically referred to the consent order being the triggering act for his suspension or revocation, rather?
Well, what our argument is basically saying is that the same outcome would have resulted either way, and when an outcome would not have been substantially different, but for the alleged negligence.
But isn't that more an issue for summary judgment as opposed to on a A7 motion?
Well, I don't think so, Your Honor. I mean, this court has countless cases where they dismiss legal malpractice claims on this exact basis when there has been impermissible speculation and when but for proximate causation is lacking.
Is it clear whether your client even knew about the fact that the SEC and FINRA was taking this position? And maybe had they known it, they may have been able to negotiate something with the Department of Banking, which would have allowed the plaintiff to continue to be associated with the firm?
Well, I think that
firm.
I think that gets at the heart of our speculation argument, because the respondent says, well, the Department of Banking would have responded differently, but that is textbook speculation. It depends on.
But was there a basis to believe that the 3-year suspension will be interpreted by FINRA as disqualifying? Was a disqualifying event? That's not speculative. They always have, right? That's why you include it in your own consent orders in settling other disputes, right? That's sort of standard.
Well, I think that the Department of Banking was very clear that he had to be suspended for 3 years, and regardless of how that was worded, it would have been interpreted by.
But the question is the significance of the 3-year suspension, right? And whether Mr. Mayor whether he needed to evaluate that 3-year suspension and how it will be interpreted. That's sort of what his claim is, right?
Well, I think that the same outcome would have resulted either way. And
Look,
Well,
I
is there an
mean,
issue whether your client even knew of the SEC, of the SEC and FINRA outlook and the Berman matter?
well, I'm not sure that that's relevant because again, the same outcome would have resulted. And you are not permitted to, you can't survive, you can't go to discovery and you can't survive dismissal if your claim is impermissibly speculative.
Not if the documents that you need to get rid of the speculation in your possession. If the documents that he needs, you're his counsel. So counsel has documents that would allow him not only to oppose your motion, but to determine the effect of that 3-year suspension.
Well, Your Honor, he has those documents, and he is in a better
But
position.
he says he doesn't, and the court believed that he didn't. So
Correct, but he
what
does
am I
now.
missing?
That's correct, Your Honor, but he does now. This court ordered essentially ordered discovery. We turned over the client file, and he has that in his possession. He was permitted to file a supplemental record, so he is in an even better position than he would have been ordinarily. And now that he has those documents, our position is that he still cannot state a claim for legal malpractice. I just want to make one more quick point.
I'll give you 30 seconds.
Yeah, with respect to the outcome not being substantially different, we cite in our papers a separate proceeding instituted by FINRA, what I refer to as the DOE complaint. That started before the consent order was executed in 2015. This proceeding started in 2014, and that resulted in a sanction that the respondent does not dispute would have resulted in him being statutorily disqualified if he hadn't been already. And I'll reserve the rest of my time for rebuttal. Thank you, Your Honors.
Are you muted?
I'm sorry, Your Honor.
That's okay, Mr.
It
Cook.
froze. It pleased the court. Matthew Kaufman for Mr. Myers. First thing, Your Honor, if I may respond to the DOE matter that he referred to, that was only prohibiting my client from acting as a supervisor, not an industry bar. So right now we have a stretching of what the terms are. Secondly, I did not get the full client file. In fact, in my supplemental record, there are emails and the like between the Department of Banking and the defendant law firm between pages 9 and 32 of the supplemental record, which were never provided to me. Or there's talk about the revision in the proposed consent order. That was never provided to me. So in fact, while counsel has represented, I haven't gotten the complete client file, and there had been follow-up emails on it, but I was not going to spend the time with the court for additional discovery. Of course, as you see, this case comes in an unusual posture that lower court had made a decision before I had a chance to put in opposition papers, exhibits or lies.
As part of your position here that maybe had you been properly advised and if you had known about SEC and FINRA's rulings, you may have had to take a suspension, but you could have avoided having, your Series 24 license would have been suspended, but your other license may have survived so that he could have remained affiliated with the firm. Is that where you're trying to go?
That's exactly where it is.
Is your adversary correct that that's really speculative because the result would have been the same?
No. And let's look at the record at page 160 and then at the record again, 374 to 76 with the Connecticut Council with his request for reconsideration to the Department of Banking and then later his affidavit that Mr. Myers' personal conduct was not an issue in connection with any of the underlying allegations. Mr. Myers was not a direct supervisor whose conduct was at issue. That is, in fact, the documents that were submitted to the court below as part of Movement Appellant's own record. So in fact, there is a question of fact as to whether was the Department of Banking really interested. In fact, the lower court, in the Department of Banking proceedings, the attorney had said that they were never interested in barring Mr. Myers, except this is a point important, before signing
You
the
mean they would
consent
have
order.
suspended the Series 24 license, but not the other license?
What would happen is there would have been the offer of the series suspend, and then, as the defendant did in 2 other state regulatory cases, he could have then profited to FINRA for their review to see if that would have resulted in a bar. In fact, defendant, it was actually given in an email to my client, see what I did to these other 2 cases. And it's there, it was presented to the SEC. This is what is done. We didn't realize this. The states are not really interested in doing the bar. And then he went back to the state regulatories, and the regulatories revised the consent orders consistent with what FINRA would accept as non-barring. And in fact, from these papers on R1 Record 160 and Record 374 to 76, that it looked like prior to signing the consent order, the state was not interested in barring him. And remember, they said, it says what it says. They were taking no position. We have, this is what is in their writings. What's afterwards is based upon testimony and not even affidavits, but statements made in papers. So we really have a question of fact as to whether the agency would have accepted and revised the consent order further. But there is no question, there's been no denial that the defendant had said to, as alleged in the complaint on paragraph 42 of the record, I believe it's page 22 of the record, that what's the downside of this? Nothing except you pay some money and you're suspended for 3 years. That's it.
I mean, part of your position is that the defendants just didn't know what the impact of this suspension was going to be, that they themselves didn't realize it, that they had kept up with the latest rulings and didn't realize it.
And in note 9 of the NAC determination, counsel was in fact chastised because of this, saying that you should have known since 2013 that this was our change of position based on the Oxley SOB amendments. So did he not know it? Absolutely. Absolutely. As I said, the NAC chastised counsel for not knowing this.
Thank you, counsel.
Thank you very much for your time, Your Honors.
1 minute rebuttal.
Yes, just want to make a few quick points. The other proceeding that we've been talking about from FINRA, the DOE complaint, that sanction did indefinitely bar Mr. Myers from associating with any FINRA member firm in a principal or supervisory capacity. That meets the definition of statutorily disqualified under the Exchange Act, and I don't think that Mr. Myers disputes that sanction qualifies as such a statutorily disqualification. The DOB, the Connecticut Department of Banking, said that they wanted to quote unquote put him out of business in Connecticut. They were, it's speculative to assume when they would not amend the consent order after it was signed, to assume that they would have done something differently beforehand. Lastly, the other proceedings that the respondent references, those were different proceedings in different states, and there's that it doesn't change the fact that it's completely speculative that the DOB would have done anything differently in this case. Thank you, counsel.
Thank you both.
Thank you, Your Honors.
Kalea versus Fagerman.
Good afternoon, Your Honors. May it please the court, my name is Eric Bailey. I represent the defendant's appellants in this matter. While a following driver must anticipate foreseeable stops, those stops must be foreseeable under the prevailing traffic conditions existing.
Well, counsel, this accident happened when the parties were trying to merge onto a roadway, right? Isn't it foreseeable that there might be a stop when someone is trying to merge onto an active roadway?
Actually, Your Honor, that isn't what happened, and that is part of the crux of our argument, is that the court below, while parsing the
Mr.
affidavit,
Bailey, before you continue, do you have another device on? Because
No,
we're
I
getting
don't.
an echo.
I actually don't, Your Honor.
Okay. Can everybody else mute except for Mr. Bailey and the judges?
Thank you, Your Honor.
Go ahead.
Hopefully that's better. My answer is that the court did not review the plaintiff's own affidavit. The plaintiff's affidavit states that the plaintiff doesn't say that he was merging. It says that he was traveling on the parkway at the time of the incident.
But he had just got, but Mr. Bailey, he had just entering the right-hand lane from the entrance ramp to the Henry Hudson, I guess, or maybe it's called the West Side Highway there at 72nd Street. So he's just getting on that right-hand side. I mean, it's really merging into the full lane. The cases that you cited were really cases where they were going along the highway, at full 60 mile an hour speed or 55 mile an hour speed, and may have unexpectedly stopped. But here, it's still that merging process, which we've all done if we drive in New York City.
Your Honor, I don't believe that the speed of the vehicles is what's important. What is important is the context that are described. And let me explain what I'm saying. The plaintiff has indicated not that he was merging, he was driving on the highway. Now, the contact is not a contact where my client made contact with the passenger side of the plaintiff's vehicle. The contact occurred from behind a vehicle traveling.
But isn't it, counsel, isn't it correct that the contact occurred simply because your client was following too closely the plaintiff as plaintiff was merging onto the West Side Highway? I mean, it seems to me that's what happened. And we have lots of cases that deal with the issue of sudden stop and whose responsibility that is. And as my colleague pointed out, the cases you rely on certainly are very different than what occurred here, no?
Well, just saying the fact that the vehicles, that this was a hit in the rear, and this isn't just about the possibility of a sudden stop. What my client contends is that this was a stop that occurred for no reason. Not
right, a sudden stop.
Well,
no.
Right.
No.
You're saying for no reason, but what you failed to explain is why you did not maintain a safe distance. Because had you maintained a safe distance, you would not have rear-ended the driver in front of you.
The other side of that proximate cause argument is if the other vehicle had continued as it should have in the absence of an emergency, my client couldn't have made that contact. The fact is,
you say as he should have, but that driver is merging, which is what makes this case different than the cases that you cited.
That, again, first of all, requires the assumption that this was a merging situation, which we contend that it was not. Further, as I believe it was just Kaepernick mentioned, this was an area that might very well have been
Kaepernick is a football player. It's okay.
My apologies, Your Honor.
Okay.
This may very well have been a part of the roadway that is part of the West Side Highway. Now that becomes very significant, quite frankly, because under VTL 1202, you are not permitted to stop on a state highway. The fact is that if this
that's to the extent, only to the extent that there are no other cars coming behind you or once you're merging. You can't merge onto the highway if there's a car coming in at 50 miles an hour already in the highway.
That's very true. And that's the reason why, first of all, my client stated that there wasn't any such situation. Equally importantly, this accident happened on a Wednesday night on this highway near midnight. This is not happening during rush hour where stops are expected. And quite frankly, at bare minimum, as Your Honor just pointed out, there is an issue then as to whether there was a car coming at 50 miles an hour, whether that has to do with the traffic conditions existing at the time of the incident that my client was never permitted to explore.
Okay,
At
thank you,
bare
Mr. Bailey.
minimum, thank you.
Let me hear from the respondent.
May it please the court, I'm Alan Zachary for the respondent. I think that the panel seems to have it right, that the cases where a sudden stop, the few cases where it's been found sufficient to rebut the presumption of negligence, involved, free-flowing traffic on an expressway. The classic example was where a
Counsel, this is Judge Singh. Can you clarify where precisely did the accident occur? Because now your adversary seems to be making an issue out of it.
Well, I'm not sure how. I mean, the defendant's own affidavit makes it very clear that it's right at the point of merging onto the West Side Highway or the Hudson Hart.
Well, that's defendant. What is
This
your
is
client?
at 72nd Street, right?
Yes, it's near the entrance of 72nd Street
Onto this West Side Highway.
on the West Side Highway.
Is there a stop sign there when you're merging?
Yes, there is a stop sign, and defendant's affidavit was after both vehicles stopped at the stop sign, and then plaintiff's vehicle stopped again after the stop sign.
Right, so you stop, right? So the front vehicle stops, looks to make sure that there's no cars coming, and then proceeds, right?
Then proceeds.
So the car makes a stop, moves forward to make sure that there are no cars coming, and then gets rear-ended by the defendant.
Yes, Your Honor.
Okay.
And one thing to note from defendant's affidavit is that she says that she's turned around back, looking over her shoulder to check for traffic behind her. And it strongly suggests that before she turned back around and looked forward, she started to accelerate in that direction, which would establish her negligence for her lack of attentiveness. There's case law that supports that because she didn't look, she started going forward before she looked back to see, because if she had looked, and the plaintiff was in fact stopped in front of her, then she would have seen that, and this could have been avoided. And
I'm sorry, I have one more question, Counsel. Can you address liability with respect to Bancorp?
Bancorp, I believe they made
referring to
another.
the Graves Amendment. How do you come within it?
Yes, at this point, we that wasn't briefed on this particular appeal, but I believe there is a pending motion from Bancorp for summary judgment before the lower court right now.
But why weren't they entitled to summary judgment on this motion? Why did they keep them in?
Oh, yes. That would be, obviously if they get dismissed on the Graves Amendment, then they wouldn't be entitled to summary judgment against them on this motion. But as far as the remaining defendants.
Are you saying that it's because that they did not affirmatively cross move for summary judgment on this motion that you didn't really deal with that below? Is that what you're saying?
Yes, Your Honor.
Okay.
Summary
why
judgment,
shouldn't they be
of course,
granted?
searches the record.
Well, if you search the record, then the plaintiff wouldn't have had the opportunity to present the evidence on that issue. It involves completely different facts than what are involved in the particular issues that are on this appeal.
Let's go back to the affidavit of the defendant. Is there anything in the affidavit of the defendant to suggest that there was a mechanical failure, the brakes failed, car suddenly accelerated, anything like that?
No, Your Honor.
Give pause. So what evidence would bring you within the Graves Amendment?
At this point, discovery has not produced any evidence.
But you moved for summary judgment without full discovery. So it seems to me that you can't really argue it both ways, make the same argument, right?
Correct. I mean, we moved for summary judgment on the issue of liability based on the.
But without full discovery. Without full discovery, you could have waited and done it later. So why shouldn't we search the record? I think is what we're trying to ask.
Right, and that would be, that's the court has the authority to do so. But having not fully briefed these issues before the court,
But that was your choice. I mean, that was your choice. I mean, the strategy that you've taken in prosecuting this case would contradict the idea that Bancorp has any liability. I mean, you're not claiming this accident happened because someone didn't have proper maintenance. You've claimed it because you were hit in the rear, and you've never suggested, no one's ever suggested in any way, I mean, and the defendant out and out denies it, that's an issue with maintenance.
Right. So at this point, based on the evidence that's out there, and we did make the motion, so there would not seem to be a basis to hold them in under the Graves Amendment.
Okay. Thank you, Mr. Zachary.
Thank you.
Mr. Bailey, you have 1 minute.
Thank you. Again, we have a statement from counsel about things in the affidavit that strongly suggest things. The problem in this case is that we're relying on parsing of affidavits rather than relying on discovery and depositions and the things that.
But I don't understand, counsel. I don't understand. Your client gives a very detailed affidavit as to what precisely happened. What more do we need than the affidavit she gives, coming to the entrance ramp, the stop sign, et cetera, et cetera, et cetera? What more is necessary for us to decide?
The testimony of the plaintiff as to their role. The fact is that the plaintiff is nothing else, is culpably responsible, and that is a rule of issue that we should be allowed to be presenting at trial, regardless of whether this is found to be a summary judgment case or not a summary judgment case. And the fact is that one of the other issues that needs to be explored is the responsibility, given the fact that this happened not on a parkway as represented by the plaintiff, but on the West Side Highway, which falls within the highway law as a place where a car is not permitted.
But your client admitted to say that it occurred at the entrance ramp of the northbound Henry Hudson Parkway. That's an admission from your client in an affidavit presumably prepared by you. Correct?
Your Honor, regardless of the actual physical location is not a matter of admissions or not admissions. It's an actual existing fact. And that fact changes the law and changes the responsibilities and imposes liability on the plaintiff.
Thank you, Mr. Bailey. Thank you both. Endodelix?
Yes, Your Honor. Peter Schneider for appellant. May it please the court, Your Honors. Judge Scarpula, who is the trial judge in this case, her final decision and order in this case awarded the collateral securing the note made the subject matter of this case, thereby extinguishing it. Then 2 years later, 2 years after trial, without an order from any judge, a clerk entered a monetary judgment, thereby creating a double recovery. That is the collateral for the note and then a monetary judgment on the note. Per CPLR 5016, Your Honors, judgment upon the general verdict of a jury shall be entered by the clerk unless the court otherwise directs. If there is a special verdict, as there was in this case, the court shall direct entry of an appropriate judgment. In the absence of a court
Well, isn't what's
order,
supposed to happen here?
yes, Your Honor, in the absence of a court.
This is Judge Friedman, I have a question.
Yes, Judge.
If you take the position that Endothelix owes money here, which is what happened below, then Endothelix owes the amount of the judgment, but at the same time, pending the payment of that judgment, the defendant has been granted a security interest in the device until the judgment is paid off.
But that's not what was ordered by Judge Scarpula, Your Honor, because of the language in the contract itself, which I'll get to in a moment. But I think
Wait. I'm looking at Judge Scarpula's post-trial decision. I guess that's the last thing that she did in this case, because I think she came to the appellate division that month. So on July 21st, 2020, Judge Scarpula signed a decision, and part of it asked for a declaratory judgment relief. And on page 17 of the record, she granted that, saying because of Endothelix's default, Vaso Medical is entitled to a worldwide exclusive license, blah, blah, blah. So she wrote that in an order, and at the end of that decision, she said, this constitutes the decision and order of the court. So that, when it says it's the decision and order, we've all been trial judges, and we know if you put that in there, then you don't need any kind of subsequent order or anything else to make that official. So she issued that. The money judgment never got entered, and that got entered, and I agree with you, it's a little strange, but that got entered afterwards. So your claim is that these are like a double, a duplicate recovery, and that's sort of your argument in your briefs, isn't it? That you can't get the money and the declaratory judgment, although the jury found the money judgment, and the subsequent decision of Judge Scarpula declared that they were entitled to an exclusive license, and that's what you're complaining about, right?
Yes, Your Honor. I think you have it essentially right. At the record, page 780, lines 5 through 11, Judge Scarpula specifically said to the parties during the trial, if the jury awards damages, i.e. money, that are not consistent with the agreement of the parties post-trial, I will have to deal with that. That's exactly what she did. And when you look at the agreement,
isn't the defendant entitled to both? It's just that the result of both cannot be more than the amount of the defendant cannot recover more than the amount of the judgment.
No, Your Honor, because that's not what the contract says. That's not what the security agreement says. Judge Scarpula
isn't it exactly what the security agreement says? And I point you to page 1878 of the record. Upon the occurrence, 1878 of the record, upon the occurrence of any event of default and at any time thereafter, while the same continues, the lender will also be automatically and immediately granted a worldwide exclusive license on all intellectual properties defined as collateral and pay borrower a royalty equal to 5% of net sales by et cetera, except that the royalty shall first used to pay back to the lender all outstanding debts, including the entire amount of principal and interest, until all outstanding debts are paid off, upon which time the exclusive license shall expire. So you get the license until you get paid, and once you get paid, the license comes to an end, but you're not supposed to get more than what your debt is.
Okay, that's not what Judge Scarpula found. What Judge Scarpula was relying on was that the company, Endothelix, and I'm reading from the security agreement, is securing its obligations under this note. Okay?
Well, I just read you from the security agreement, right?
I understand, and I'm reading from the same security agreement, Your Honor.
Right, but you rely on what Justice Scarpula said. Let's put aside what Justice Scarpula says and look at the language of the agreement.
Okay, so given that, Your Honor, this was still a special verdict. It was not a general verdict. Therefore, the monetary judgment, rightly or wrongly, would have had to have been ordered by a judge. Judge Scarpula had a lot of opportunities to submit, or to order rather, monetary judgments that were submitted to her back in July of 2019. She chose not to do so. Judge Peter Sherwood in July of 2020 chose not to do so. It was only a clerk on January 4th, 2021, 2 years after the trial, having been contacted by a respondent, that on the clerk's own entered a money judgment. So Judge Scarpula's order does not.
That's for us to evaluate, right? We're an appellate court. You keep referencing what was done. That's under examination by this court.
Yes, sir.
Right. So we know what the lower court did and what the clerk did. So tell us why you think we should allow you, given the language that was read by Justice Friedman, why we should allow the defendant to double recovery, basically.
Well, I don't think you should allow the
Right,
defendant
you
to double
don't, right?
recovery, and they have
So-
they
so
were
the
not
question
awarded.
is, do they get the 702,000 plus, at which once the debt has been satisfied, or has been paid off, and at which point they will not have the exclusive license.
Okay, that's not what is in the order of the court. So when I go back to look, and I
No, but
understand,
is that what it says in the paragraph that was read by Judge Friedman?
I don't believe so. No, Your Honor. I think that that's reading a portion of the agreement. But if you read the full agreement, Your Honor, appellant's position is that the collateral and the intent of the parties throughout, and the reason that they use this as collateral is because it was equal to or greater than the value of the money under the note. And that's what they were awarded. Judge Scarpula didn't say, well, they have the collateral until such time as you pay off the note.
But why?
It's rather clear. It's rather clear what the agreement is saying on page 1878. I mean, it says you get this collateral to pay back what you owe, and when you finish paying back what you owe, then that collateral, that lien that you've got, that security interest, comes to an end. I mean, isn't what you do keep referencing what happened below, but isn't the bottom line here, if we could focus on that for a moment, you owe $702,000 as it's been determined below. If you paid up to $702,000, the Vaso Medical would be entitled to nothing under the security agreement. They'd lose their exclusive right to it, and that's the end of it. If you don't pay back the $702,000, then they can continue to try to extract money from that collateral that they have from that worldwide license. But as they're making that money, that's going to pay down what you owe under $702,000. Isn't that what this case, what the result that's supposed to happen here?
What's supposed to happen and what actually happened are two different things, which is
So
why.
are you saying that you think that the ultimate judgment or order has to be modified so that it provides clearly that once they recover the full amount of the what's owed under the note, that the exclusive license is no longer in effect?
That's certainly one possible remedy that I have considered in my mind, Judge. Now, there's extensive briefing in this case, and I don't have time to go over every point of error that we have. There's a lot of grounds in our briefing where we think we're entitled to a new trial, but I thought this particular issue, because I knew the court would be focusing on it, is one that we should talk about. Now, that is one possible result, Your Honor, on this issue. The result I would be seeking on this issue is to do what, the trial judge, Judge Scarpula, said in her order, because remember, there's only one post-trial motion that a party gets to file, and they have to ask for all the relief that they want in that post-trial motion. The only thing that respondent asked for in their post-trial motion was this declaratory relief. They didn't ask for monetary judgment.
But they already had a monetary award from the jury. So, I mean, that doesn't go away just because it was like, okay, we like the monetary award. We don't have to make a motion about that. We're only making a motion about the things that we don't like or that we want the court to review. No?
I hear you, Judge, but that's not what the rule says. The rule says that the single post-trial motion rule says that every ground for post-trial relief then available to a party must be in the single post-trial motion. Well, one ground for relief is, hey, we've got this verdict, a monetary verdict. Let's convert it into a judgment. That wasn't asked for because it wasn't proper. They asked
Schneider, can I ask you a simple question?
Yes, Your Honor.
Has the plaintiff derived any income from the exclusive license?
No, Your Honor. Not that I know of. I'll preface it with that.
So there's nothing to offset from the 702,000 plus.
Well, there was a small amount in a bank account that was taken, I think a few $1,000s. I'm not sure
Okay.
of the amount. But other than that, no.
Okay, thank you, Mr. Snyder. Let's hear from the respondent in this case.
Good afternoon, Your Honors. Mark Gottlieb for Vaso Medical, which was the defendant and is the respondent in this appeal. Good morning. Good afternoon, Mr. Schneider. I agree with Judge Kapnick on this, that we got nothing more than what we were awarded. At the beginning of the trial, Judge Scarpula said to us, we had various issues to discuss, including declaratory relief, what was going to go to the jury, injunctive relief, and Judge Scarpula was very clear. She said, look, those are decisions that I will make post-trial. Let's see if you win first. If you get a jury verdict and you're awarded damages, then I will deal with the issue of injunctive relief and declaratory relief on the security agreement. We all agreed to that. Whether we agreed to it or not, that was the court's decision. After the trial, the jury verdict came back in favor of Vaso Medical, and we were rightly awarded over $700,000 in damages. We then took the judge up on what she told us to do. She said, now that you've got the award, make your post-trial motions for the additional relief. That was the declaratory.
The declaratory relief is not the kind of relief that goes before a jury.
Correct. That's right, Your Honor. And Judge Scarpula properly determined that. Nor was the award of attorney's fees. Judge Scarpula determined that under the contract, we were entitled to attorney's fees, and we were entitled to the declaratory relief to secure us for payment of the judgment. Your Honor's had it correctly.
So you agree that once you get paid the $702,000 plus, that you no longer have the exclusive license?
Absolutely correct. That's exactly right. We do not have it anymore once we're paid back.
Could I ask one question, counsel?
Sure, Judge Singh.
Not in the record, but just intellectual curiosity. Have there been attempts to collect royalties based on this equipment?
No, there have not been. And one of the reasons is because it would take a large investment. And while this appeal is pending, nobody wants to invest that kind of money in this thing until we know how this is going to shake out. But getting back to the judge's decision, I want to point out to the court that we have not been granted anything more than what we won. We won the $700,000+ damage award from the jury. That was put in the judgment. We were granted post-trial the relief for declaratory relief and attorney's fees. The attorney's fees amount was going to be decided by a referee to refer it to here. We've never gotten to that point. And I also want to point out to the court what was going on at this time. It cannot be ignored. We granted
a stay also of that, right? Weren't there motions up here too?
No, I don't believe there were any motions. I don't recall that.
Okay.
So we were
but at the end, you're entitled to $702,000. You're also until you collect that money, you're entitled to this license. If you make any money off of the license, it comes off of the $702,000. Is that correct?
That is absolutely correct. Absolutely correct. You're all reading the agreement exactly right. There's no great shakes here. Where I think counsel is going wrong is where he believes that under the rules that the motion that we made for the post-trial relief, which was the injunctive relief and the declaratory relief, that by us not including the monetary relief, somehow we waived that. I don't understand that.
How is a judgment fashioned which awards you the $702,000, but at the same time recognizes that if you're making money off of the license, it comes off of the $702,000. I mean, it's not your typical judgment in which you're awarded $702,000 and that's it, because the $702,000 then has to have credits against it for the money you're making off the license, if you are in fact making any money off the license, which you say you're not.
Well, we're not, but you're right about all of that, except that that would be within the declaratory relief, basically, because the declaratory relief gives us the exclusive rights until we are repaid. So it is within the judgment.
So that does not. I mean, can you keep the judgment the way it is? The judgment that was entered by the county clerk. That's who enters judgments,
yes.
Money judgments. In January 2021, is that judgment consistent with the limitation on the declaratory relief?
I believe it is, Your Honor. I believe everything the court granted us was what we were given by the court, either by the jury or by Judge Scarpula post-jury. Nothing was given to us that we didn't get originally. There's no double dipping here. We're not being awarded two separate things. They get credit dollar for every dollar we collect. Now, of course, interest is going to be accruing on that judgment as of today or as of the date of the issuance, but we're not getting anything more than what we earned at trial. They're trying to get a second bite at an apple after a jury determined on all the evidence that we were entitled to this money back. And he's trying, counsel is trying to be cute with claiming that we had some kind of procedural error because we didn't ask for the judgment to be included in our post-trial motion. Why would we be asking for that relief in a post-trial motion? That's not the relief you ask for. You ask for all the other things so that
You got
we
that
should get
relief
those.
already from the jury, right? You got that
The jury verdict.
relief.
Correct. So all we were doing is waiting for the rest of the relief so we could fashion a judgment that would include everything. You don't have to ask for something we already got awarded by a jury verdict. I think that's where the fallacy is here. On the other issues, Your Honor, we'll stand on our brief. I think that they are fairly clear.
Thank you, Mr. Gottlieb. Mr. Schneider, you get a minute.
Yes, there's no fallacy here. When you have a special verdict, as we did in this case, whether it's the award of the collateral, whether it is turning the jury's verdict into a judgment, when you have a special verdict, which this was, a judgment requires, it must be pursuant to the order of a judge. Judge Scarpula had ample opportunities with Mr. Gottlieb submitting multiple judgments for money in front of her. She chose not to sign any of them before she issued the order that she did. So to this day, we do not have compliance with the rule.
Counsel,
where a
I'm sorry.
judge.
I'm sorry to cut you off, but can you please go back to the question that Judge Friedman asked you in the beginning? Why is that language not appropriate? In effect, it's a basis in the security agreement to give the judgment creditor a right to enforce the judgment. Your client presumably is a startup, single-purpose entity, probably not much money in it. The agreement between the parties is what's of value. It's the royalties. It doesn't the agreement fully, isn't it consistent with what your adversary is arguing?
I don't believe it is, Your Honor. And what the end result is, despite what may or may not be in that agreement, the end result in this case, if you look at Judge Scarpula's order and the way that it was written, it granted them the collateral. It didn't say you have use of the collateral until such time as the judgment is paid.
But that's what the security agreement says. Judge Scarpula certainly couldn't rewrite the security agreement, correct?
She didn't. Judge Scarpula read the part of the security agreement where the company was securing its obligations under the note by the grant of the lien and came up with the decision post-trial, just like she indicated that she would do. And that's exactly what she did.
Let's assume for the purposes of my hypothetical that this instrument is worth $1 billion in the market. And what would the judgment creditor be entitled to under that scenario and the security agreement?
Well, I think that they would be, if it was worth $1 billion in the market, they were awarded that, they'd be thrilled. And I think
it's your argument that they'd be entitled to $1 billion?
If that's what the security was for the note, then
so you would not be pushing the position that they're only entitled to a judgment to the amount of what the judgment is, interest, attorney's fees.
Your Honor, I think that would have to depend on what the agreement said. I know what this agreement says, and this was done.
If it was worth $1 billion, you would be pushing that we pay the $702,000 and the security interest is over.
You may be right as a lawyer, Judge. I may take that position, but again, that's a
lawyer. How about as a businessman?
It's a hypothetical that.
How about under what the contract says?
The reality of what I'm looking at is that there is an order issued by a judge, which can be turned into a judgment, and there's a judgment that was issued by a clerk that was never ordered by.
But you keep relying on the order. On the orders below that are under review by this court. And what I'm suggesting to you is we need to look at the agreement based, on the record, 1878 paragraph 15. the jury has played a value on the debt, right? 702,000 plus. So we are saying, we are reading now from the note itself. Forget about the orders that we're reviewing. We're going to make up our own decision, right? And our decision has to incorporate both the nature of the exclusive license versus the debt that it has to be paid. Look at the language in 1887 and decide, look at it, until all outstanding debts are paid off, upon which time the exclusive license shall expire. I mean, that's not mysterious to me.
It isn't, Your Honor, and quite frankly, I agree with everything you just said, and I'm thrilled that Your Honors, who have a reputation for thoroughness, are going to look through this and make your decision. That's all we as litigants can ask for. And along those veins, I'll close by saying, you know, we focused on this particular error here today during our oral arguments, but there's, you know, 120 pages of briefing that I know the court's going to look at, and we'll await and look forward to your decision.
We have had a lot of fun reading it, and we'll reread it again before we decide. So I thank you both, Mr. Schneider and Mr. Gottlieb.
May we be dismissed from the call entirely, Your Honor?
Yes, you may. Yes,
Thank
you may.
All right. Bye-bye, Judge. Thank you.
Okay. People versus Feliz. It says Feliz.
Yes, Your Honor. May I proceed?
You may proceed, Ms. Gonzalez.
Thank you, and may it please the court, Alma Gonzalez for Mr. Feliz. I'd like to focus my time on point 1 of our brief. The main question before the court is fairly straightforward. Can subject matter jurisdiction be created retroactively by designation? And the answer is no. There is no legal authority either under the Constitution.
Wasn't this originally decided by the Court of Appeals in the People versus Correa case, in which they decided both the powers of the chief administrative judge to decide the creation of this particular courts, right? This criminal division, and its hybrid nature.
No, Your Honor, because this case is different in the sense that we're not challenging the chief administrator's ability to designate someone to be in acting justice and create a hybrid part. What we're saying is that designation never happened before the plea.
But counsel, wouldn't it be fair to say that by putting the judge in the hybrid part, they are a de facto acting Supreme Court judge?
I mean, that's usually what it means, right? A hybrid court, like any problem-solving court dealing with superior jurisdiction, that judge, that presiding judge, and I was one of them a million years ago in the Harlem Community Justice Center, that judge gets acting Supreme Court designation. So when that judge is acting on the non-criminal court part aspects of the case, that judge is an acting is a Supreme Court justice with all of the powers of non-indicted. Well,
that would have been the case had the chief administrator designated the judge to that part. But the problem is that we have this administrative transfer order dated for July 2016, where that designation is being made after the plea and not before. And that order controls here, Your Honor. I think, under the presumption of regularity, in the normal sense, yes, if the judge was in that part, then we would have no other reason to challenge it.
I'm not understanding, Ms. Gonzalez, that the case is in a hybrid court, right?
It is a hybrid part if the judge is enacting justice.
No, but the hybrid part is comprised of cases that are both Supreme Court and criminal court, right?
Correct, yes.
So that judge gets paid, and he has all of the powers of any other acting Supreme Court justice that has jurisdiction over all cases, right?
Well,
non-indicted misdemeanors and others.
Correct, if the chief administrator had designated them to be enacting justice, but that didn't happen here. No, because we have, if if your honors would look at Administrative Transfer Order 120, which is in the record, that is where, you know, the chief administrator is saying, I hereby temporarily designate Judge Rodriguez to be in that part. But the problem is that it came after, and the effect of that is essentially that the court is granting jurisdiction retroactively. That's the effect.
Let's assume, counsel, for my hypothetical, that didn't occur. But Judge Rodriguez was sitting in the de facto part, which is part criminal, part supreme. Are you suggesting first that you'll agree that the part is lawfully constituted, correct?
It's lawfully constituted if the judge was enacting justice.
The judge has
yes.
been now designated by the administrative judge to sit in that part. Doesn't that, just by sitting in that part, confer acting Supreme Court justice status upon the judge to be able to effectuate decisions as a Supreme Court judge?
In the regular course, yes, but the chief administrator had not designated him to be an acting justice at that time.
He was assigned to that part.
But
by
we
placing him in that part, they are designating him to conduct all of the duties that part would require, which is the hybrid part, right?
But the person who designated him to sit there wasn't the chief administrator, and under the Constitution, only the chief administrator can designate someone to be an acting justice at that time. And we do have this order, you know, the order of the chief administrator is not a superfluous order. I mean, it was rendered after the fact and not before. And the effect is essentially that this does away with the jurisdictional requirement, because what could happen in the future is that, you know, anyone could take a plea in criminal court and then everything is just cured because, you know, there's an order after the fact saying, yes, this person.
But you're not agreeing a plea in criminal court wouldn't be a plea in a hybrid part.
Sorry, Your Honor, I didn't catch the question.
A plea in criminal court wouldn't be a plea in a hybrid part.
If it was in front of a,
I mean, there's no question
criminal...
this is a hybrid part, and no one's suggesting that the judge just showed up there one day without being told by the administrative powers, go and sit there. This is your assignment.
And we're not, you know, we're not suggesting that, you know, he wasn't sent there. We're just suggesting that there was a mistake here, and it was a mistake made by someone who wasn't the chief administrator, who is the only person who has authority to place him there.
Yeah, but who do you think creates the Part FA in a hybrid court?
It's the chief administrator, Your Honor, but the point is that
the consent of the presiding justices.
Correct.
Right?
Correct.
So
but
that took place, right?
Correct. Yes.
Because that part was created. So the administrative judge of the Bronx is the one that administers that part, correct?
Correct.
And that part has jurisdiction over both criminal cases and Supreme Court cases.
Yes, and we're not contesting that, you know, this was a hybrid part. We're just saying that the wrong judge was sent there. Someone who did not have, you know, acting justice authority was sitting on that bench that day for reasons unknown, obviously, but we do know that the acting justice designation was given after the plea and not before, because we do have an order that says that.
I see the argument. Okay, we took a lot of your time, Ms. Gonzalez. That's the issue you wanted to focus on?
Yes, Your Honors, yes. And I would just, if I can make one quick point before going to respondent, that, you know, the logical endpoint of respondent's position here is that we don't have standing. So I do want to get ahead of that and just say we do have standing to challenge someone's authority to be in that position for the reasons cited in our reply brief.
Okay, thank you, Ms. Gonzalez. Let me hear from the people.
May I proceed?
You may proceed, Counsel.
Good afternoon, and may it please the court, John Commendoria for the people. Your Honors, in resolving
So it sounds like that there's no question that the paperwork didn't catch up with what was actually happening in the courtroom.
Correct, Your Honor, and I'm sure Your Honors are aware that...
So does the paperwork not matter? Does the fact that this order has actually been issued, does that not matter?
So, Your Honor, twofold response to that. Initially, that it's post-dated doesn't really matter. The fact of the matter is that it was still issued. There's no rule, law, or constitutional provision that requires a judge's assignment be in writing. It doesn't, and piggybacking off of that, in denying the CPL 440 motion
No,
post-judgment,
but it's not true. I mean, a judge is presumed to be part of the court that he or she is elected. If it's a civil court judge, if it's a criminal court judge, the presumption is he or she was appointed by the mayor, right? So their jurisdiction is, in the case of a criminal court judge, is to deal with criminal court matters, etc. Once we're talking about a criminal court judge appointed by the mayor, now sitting, in effect, dealing with Supreme Court jurisdiction. That needs to be done officially by the administrative judge on the consultation with others, right?
correct, Your Honor. And just because that administrative order, that administrative transfer order is post-dated, doesn't mean those procedures weren't followed. It doesn't mean that on the day that he was assigned to those parts, and you'll notice that there are multiple set of dates in that first transfer order, it doesn't mean he wasn't procedurally and properly assigned there. It's just going to show that that form was done post-dated. And even, let's just say for argument's sake,
So Judge Rodriguez was appointed, say, was assigned to the hybrid part. So he isn't, basically has the ability to deal with hybrid cases as
Correct.
part of that assignment, and the order can catch up with him. So
Correct.
so cases that precede his appointment are not invalidated. Is that what you're saying?
Correct, Your Honor. And indeed, Justice Rodriguez himself wrote in denying the 440, I, on those days, quote, sat as an acting justice of the Supreme Court, end quote. And that's how he dealt with it in the 440, which my adversary did point out in her brief that he didn't address or redress that type of thing. I would also like to point out.
So Judge Rodriguez acknowledged he was an acting Supreme Court
Correct,
judge
Your
by
Honor.
designation.
Correct.
Okay.
And the two administrative transfer orders also confirm that. But even if Your Honors were to say, hypothetical, assuming without conceding that he wasn't properly assigned by sitting in that court part under color of authority and under color of title, he was a de facto judge. And as this court has held in People v. Campos 239 82nd 185, a defendant cannot vacate their conviction based on any alleged illegality or unconstitutionality of assigning a criminal court judge over their felony matter. And if Your Honors have no further questions, the people do ask for an affirmance.
I think we're good. Thank you, counsel.
Thank you, Your Honors.
Ms. Gonzalez, you get a minute. So Justice Rodriguez already had received his acting Supreme Court designation and said as such in the decision.
So in the 440 decision, which I recognize isn't on appeal, but in that decision, Judge Rodriguez said that he had acting justice jurisdiction at that time based on an administrative order. Didn't give the number of the order, but I'm presuming that means this administrative transfer order. And it's quite possible that, Judge Rodriguez looked at this order and decided, yes, I did, based on this order, have jurisdiction, but didn't notice the date, which is post-dated. And again, that order is not superfluous. And, to respondents' argument that we don't have standing in this case, we completely do. De facto means that the judge has a color of title given to them by someone with authority, meaning in this case, the chief administrator. And what we're saying, we are specifically challenging that.
The part was essentially established by the chief administrator, correct?
Correct, the part was.
Okay, so the part's established, then presumably the administrative judge of Bronx assigned Judge Rodriguez there. Isn't that sufficient connection to say he's a de facto? The authority derives from the chief administrative judge?
No, Your Honor, because under the Constitution, it has to be the chief administrator who made that designation. And the chief administrator in the transfer order is saying, on this date, July 2016, I am designating that person to be enacting justice. And this is a simple question.
Let me just ask this question because I just want to know: are you saying that the only way that designation could have happened is in writing? It couldn't have happened some other way, saying I'm designating Justice Rodriguez to sit in this part, assign him to that part, and then the order follows?
No, Your Honor, but what we're saying is that, in this case, we know that that wasn't made beforehand because we do have the order. The order wouldn't have been needed had there been a designation, a proper designation prior to. And we can't treat that order
Well,
as super.
That's not necessarily true because sometimes, look, things happen in court very quickly. Maybe someone else was supposed to be there that day. You need to have a judge in the part. The administrative judge has to get a judge in the part to take care of the business. And then afterwards, they make sure that they officially have paperwork so we don't have this problem which we're having today. So I'm not sure, if what you say makes practical sense.
I hear Your Honor's point, and I will add that this is a fairly simple question of fact in the sense of was there a designation at that time or was there not? Respondent didn't introduce any other records to indicate that there was a designation in 2016. All of OCA's records indicate that Justice Rodriguez became an acting justice in 2017, including the press release when he became the administrative judge of the Bronx. And so all of OCA's records are saying, he was designated in 2017, but respondent is saying this somehow happened before the fact. So
Thank you, Ms. Gonzalez.
thank you, Your Honor.
Thank you both. Wells Fargo.
Good afternoon, Your Honor. Charles Rumpfer on behalf of Wells Fargo. May I proceed?
You may proceed, counsel.
Okay, Your Honor, this is a fairly straightforward case, and hopefully I won't take up too much of your time. We are asking that the court's order dismissing Wells Fargo's foreclosure be reversed because the trial court in its order elided a crucial but maybe subtle distinction between a case being marked off the calendar and not restored and a case being dismissed. This is important because only if a case was dismissed would the statute of limitations, which started with the 2010 foreclosure, have run. If the case has not been dismissed, that statute of limitations has not run, and the trial court is incorrect in having found that respondent bore their prima facie case of showing that the statute of limitations.
How does 3404, the CPLR, play into this argument?
Well, I think 3404 of the CPLR, plays into this argument in that were someone to have made a motion, in response to one of the motions, to restore the case that were denied, I think, the court could have said, I'm going to dismiss this case under section 3404 because I don't see that you have made the showing that you need to make. I think 3404 is not sort of automatic and self.
So there's no language at 30. I'm sorry, go ahead, Judge Kavanaugh.
No, go ahead, Judge Singh. Go ahead.
I was just going to ask you, so there's no automatic dismissal under 3404?
Well,
Isn't
I think
that what statute says?
I can completely see how if you just read 3404, it seems to suggest that, but there's plenty of cases in this department and in other departments, I believe, saying, well, 3404 is, despite that language, not self-executing. What it is
Sure.
It
So for example, if the parties continue to litigate a matter, and there's been an administrative dismissal, that would be an argument to say, in fact, that it wasn't deemed abandoned because we were pursuing it. Anything like that in this case that you can hang your hook?
Well, there's the fact that the appellant was in kind of a catch-22 here. They were continually trying to restore the case. They tried several times. The court in the 2010 said, no, I'm not going to let you restore it.
But you never responded to the problems. You never responded to the problems that Judge Kenney raised.
The failure to file a certificate of military service, I believe, was the issue.
Well, didn't she say that you should, have an order to appoint the referee and go along with the foreclosure, and you never did that? And so.
Because before they could do that, they would have needed to
to restore that. Once it's marked off the calendar, they're going to need to restore it before they can file any of that stuff. So they weren't able to get their foot in the front door. So they're
Well,
caught.
okay, so you make
now in-
two half-hearted attempts to vacate the automatic dismissal. You could have appealed those orders. You don't, and then you throw up your hands and you commence a new action.
Well,
So
I guess my
under
argument was
circumstances,
that those are not an automatic dismissal, that those are just marking it off the calendar, and that now they're
So
in a
if
kind of.
that's the case, then why would you commence a new action? Just by your own action, it suggests that you knew the action was dismissed, because you wouldn't have commenced a new action if the action was still alive.
You might commence an action even if you know it might be found to be a parallel action, just because you feel like, well, I've tried to restore this case, I can't seem to get it restored, I'm going to try to file a new action.
And avoid the underlying requirements in the first place. I mean, there was a reason the judge wasn't allowing you to restore it.
Well, you would presumably need to file a motion for an order of reference that complied with all the requirements for an order of reference.
I mean, you had to have realized that you had statute of limitations problems in starting a new action. Whatever your outlook is on it and whatever you think should happen about it, but you had to know this was a problem at this point.
You know, at the time that they filed it, I think they were relying on case law that the Second Department has since disavowed, I guess, to conclude that they didn't have a statute of limitations problem. I thought, if you look at the briefs that.
But this is the first department, right? We never made such a rule.
My view is looking at the arguments made below, they were clearly under the impression that the statute of limitations had not started running, because under the terms of the contract, the statute of limit, the amount wouldn't be fully due until judgment. That's not an argument.
That was a misreading of paragraph 19, right? The fact is you accelerated the debt. Once you accelerate the debt, it's over.
Well,
the clock.
Yes, but they did have support for that argument in some trial courts at the time they made that motion, that argument. So it was reasonable for them to think that they didn't have a statute of limitations problem. I'm not pursuing that argument because in the intervening time,
Court of Appeals.
Appellate courts have made it pretty clear that argument is not going anywhere, and I'm not trying to push that argument. But I would say that it was a not unreasonable view for them to have taken at that time in 2017 that they didn't have a statute of limitations issue, to Justice Friedman's question.
Okay, thank you, Mr. Jennifer. Let me hear from respondents in this case.
Yes, good afternoon, Your Honor. Dong-Sung Kim from Kim Chuan Kim PC, appealing for the respondent.
Okay. You may proceed, Mr. Kim.
Yes, Your Honor. Like you pointed out, the plaintiff filed a second foreclosure action in December 2017. Under RPAPL 1313, without abandoning or dismissing the first foreclosure action, the plaintiff shall not file the second foreclosure action, Your Honor. So the plaintiff filing the second foreclosure action is also clear evidence that the 2010 action was abandoned and dismissed. At the same time,
you say it's abandoned because they had a year to restore the case and they did not, correct?
Oh, yes, Your Honor. Also, the RPAPL 13013, the plaintiff shall not file the second foreclosure action without abandoning or dismissing the first foreclosure action, Your Honor. So here, the plaintiff filed the second foreclosure action in December 2017. Beside the trial court in 2010, the trial court denied two motions. The plaintiff in 2010 filed two separate motions in attempt to restore the case, but the trial court denied those motions and the case never been restored. In addition to that, also the RPAPL 1313 also indicate that the plaintiff definitely abandoned the 2010 case and by the operation of CPLR 3404, and also the court denial order to resolve the case, 2010 case was correctly dismissed, Your Honor.
Okay. All right. Thank you, Mr. Kim. Mr. Genfro, you get 1 minute.
Your Honor, I think I addressed Mr. Kim's point that I would issue in rebuttal on the main argument, which was simply that the CPLR 3404, as we discussed, isn't self-executing, isn't automatic in that sense. And that's all I would have to say, unless you have any other questions.
No, I think we're good. Thank you both.
Thank you, Your Honor.
Okay, last, we have Rosengarten versus New York State and City Office for Children. Justice Bahati Pitt is recusing in this case. Let me first hear from Mr. Rosengarten's counsel.
Yes, thank you. Philip Greenberg, attorney for petitioner Martin Rosengarten. May I proceed, Your Honor?
You may proceed, counsel.
Thank you. All right, so respondents in this case failed to meet the burden to show that the child is in imminent danger and that the public needs protection from petitioner. Their entire case was based upon business records. As we established in our original brief and in our reply brief, the requirements for putting a business record in were not met. The second aspect there is that even if somehow they get past that, and I recognize—
But counsel, just on that issue, it was clear from the report that father committed the maltreatment that was alleged, right? He admitted to one of the workers that he had hit the child with a bottle. Isn't that correct?
Okay, so I'm so sorry to interrupt, Your Honor.
No, that's okay.
No, he did not admit to that at all. What he testified to, and as the record reflected, Ms. Adeniga, the investigator for ACS, spoke to him for only about 2 or 3 minutes in family court while she was sitting for 2 or 3 hours with his ex-wife. And what Mr. Rosengarten—
Well, it doesn't take a lot to hear from a child who seems to be afraid to go to Mexico with his father, right?
Well, Your Honor, that's the way it was framed, and I'm not going to go outside the record except to say that they've traveled since then. But in terms of your original question about the bottle, what was clear, and neither the respondents have disputed the fact that what happened was 1 year and 3 quarters before this proceeding was brought, Mr. Rosengarten, while his son and him were on vacation in Florida, tossed a small Poland Spring bottle to his son, thinking that he was going to catch it. He didn't notice that his son was not watching. It glanced off his shoulder or back. He was not hurt. That was his testimony.
Well, but that's one version of the events. Does the ALJ have to accept that version, which frankly is self-serving? I don't know about parents throwing bottles at kids. I know it's a plastic bottle. ALJ certainly can look at all the evidence and come to a different conclusion, no?
Okay. So, yes, and I'm glad you asked me that question, because at page 56 of the record, the ALJ said, and this was her sole basis for not believing Mr. Rosengarten, is that she said that he purportedly said that the child was hurt by the bottle and that he put a warm compress on it. Now, she doesn't refer to the record, though, in saying that it's completely made up. And not only was that contrary to the only evidence there was, contrary to the only evidence, but it's counterintuitive, because if the child had really been hurt, as we pointed out in our brief, it would have been a cold compress. And it's also
But the ALJ, Mr. Greenberg, the ALJ also found the petitioners not credible because his testimony was inconsistent with the contemporaneous statements that he made to the ACS worker at the time of the investigation, right?
Right, and that was the only statement that you found was inconsistent. Remember, the ACS worker only spoke to him for 2 to 3 minutes. And that was the only inconsistent statement that she found. She said, and again, with no reference to the record because it was completely made up, she said that Mr. Rosengarten said that the child was hurt by the water bottle, which he never did, and that he put a warm compress in, which he never told the ACS worker. And that's why, even though when the ALJ made up that fact and she frequently referred to the record, she didn't refer to the record, any page record there, because it was completely made up.
Now, Counselor, was that the only incident? Wasn't there another incident too where there was some bruising and your client had an explanation for it, which the ALJ rejected?
Well, the ALJ did not, her basis for doing that, actually, again, I want to go back to the fact that the ALJ specifically said that the reason she found Mr. Rosengarten not credible was because of this conflict about the bottle, even though the fact that she was using was made up. In terms of the black and blue mark, that was based on his former wife's claim that that the boy came home with a black and blue mark. And I just want to, and I realized that.
What about the fact that the teacher said that the child's mood improved after his visitation was changed to dinner only?
Well, that, of course, is all part of the whole business record problem. However, what I will point out.
Counsel, Mr. Greenberg, isn't hearsay permitted in these administrative hearings, some form of hearsay? And isn't there, the ALJ referred to the fact that the petitioner had a lot of these documents in advance so that you could have dealt with it during the hearing in any event?
Well, yes, we had some of them, but here's the point. You're absolutely right, and the cases are clear that in an administrative hearing, they can rely on hearsay, provided that the declarant had personal knowledge. And the courts, all the way up to the Court of Appeals, have defined personal knowledge is that they heard what they put in a report or they saw what they put in a report, and that wasn't present here. That's why I was able, both in the original brief and in reply brief, to readily distinguish all the cases cited by the ALJ and the respondent, because those cases that allowed hearsay in administrative hearings were based upon either facts that were not disputed, which of course are disputed here by Mr. Rosengarten, and were based upon statements made by people who saw or heard what they reported about.
But in this instance, counsel, couldn't one make the argument that in fact the hearsay statements were corroborated in part by your own client's statements?
Well, the answer is they were not corroborated. On the bottle, he said what I just said earlier.
The details are not corroborated, but the incidents are corroborated. So if you wanted to make this case that, oh, this is all made up, your own client undermines that sort of an approach. I mean, because they do, your own client shows that these incidents that happen, what exactly happened, he's not showing that that's what happened, but he is showing that something happened.
No question about it. But the big issue is, how did they happen? If he tossed a little bottle to his son, thinking his son was going to catch it, and if his son got a black and blue mark by banging into a bed.
But that's not how petitioner even described it himself, is it?
Yes, it is.
In any event, he was not credited, though.
No, well, what his testimony was, and again, remember, the most of this is based upon what his ex-wife said, who had no personal knowledge, and
that's also the child who you say was an interview for an hour. I agree, was interviewed for a few minutes, but that's what the child testified, and he was credited.
Right, but it was credited. It was bolstered by the testimony, by what was Ms. Mattis said, which was most of what it was, his ex-wife and his ex-wife's employee, the nanny who has worked for his ex-wife for the last 4 years.
But the ALJ also rejected your client's contention that the mother was coaching the child, and basically said that there's no credible reason why ER would lie to him.
Okay, so as Mr. Rosengarten testified, and as you know, it's reflected here, Justice Katz restored his visitation time as a result of the proceeding that came after that, but are based upon the exact same facts that you have here. So, but again, as Mr. Rosengarten testified, and again, I'm not going to go into what's come out in the Supreme Court, except as you can infer from Justice Katz's August 2019 order, everything that's come out has come out very favorably to Mr. Rosengarten since his time with his son has been completely restored. But as Mr. Rosengarten testified, literally from the time his wife filed for divorce, I think in 2012, I wasn't the attorney at the time, she has tried to use their child, the only thing she has, to get back at him for their failed marriage by trying to sever the relationship between the child and Mr. Rosengarten. And this case is part and parcel of the case that her lawyer filed ex parte the very next month in January 2019.
Okay, let me hear from Mr. Harron.
Thank you and good afternoon, Your Honors. May it please the court. Eric Herron for the state respondents in this case. The determination by the Office of Children and Family Services that Mr. Rosengarten maltreated his child is supported by substantial evidence and the administrative law judge's credibility findings and should be confirmed. I think as Your Honors have discussed with Mr. Rosengarten's attorney, the principal issues in this case were resolved by the ALJ on evidence that in some cases was conflicting or depended on credibility determinations, including that petitioner's version of events was not credible. And that sort of determination by an administrative law judge is entitled to deference by the court. I'll just go into a couple of the pieces of the record that demonstrate that substantial evidence was present here. There were statements from the child that he was punched, that the water bottle was thrown at him, that he was bruised on 2 occasions, that his father hit him on the head, that he was afraid of his father. He was afraid of traveling with his father. There were statements from the child's mother that she was aware that the father had punched or bruised the child. And there are other matters in the record, including that child's mood improved after the visitation was limited. I will point out, Mr. Greenberg has referenced a contention that the basis of the credibility finding was made up. But if you compare page 279 of the record with page 90 of the record, the consistency is plain between the versions of the event involving the water bottle. A couple of additional points. One is that I think has been noted, hearsay is admissible in administrative proceedings. There's no requirement that someone come and testify about the way the records of the child abuse system were kept and that sort of thing.
What about, Mr. Herron, what about Mr. Greenberg's discussion about what happened in Supreme Court and the reinstatement of a lot of his visitation? I mean, how do we take that weigh that in this evaluation?
I mean, I don't think any of it, other than the order that was introduced by Mr. Rosengarten's attorney in the administrative hearing, is in the record here. Our office doesn't know.
That's the problem with disordering the record, because we already have an order to which is being alluded, and in the meantime we're dealing with we solely or limited to deal with an order that was entered years ago.
Yeah, and just one point
to add, in the dark. If you can somewhat answer the question that Justice Kapnick pointed to, I would appreciate it.
Sure. I mean, just from the language of the order, it appears that Mr. Rosengarten's visitation was sharply limited in January of 2019 so that he could only see his child once in public during the week and in sports games. And then it was kind of gradually expanded by stipulation as long as he complied with a requirement to see a I don't know if it was a physician or a psychiatrist or psychologist or something about getting better parenting skills. And then the order says that he tried to get the doctor to sign an affidavit about his wife doing something about his relationship with the child, and the doctor refused. So then the court had to appoint a new physician, and at least as of the order that's in the record, none of that had been completed by at least the completion of it isn't in the record here. One final point on that order is that Mr. Greenberg said the January 2019 order was entered ex parte, but page 303 of the record says that the order was entered, quote, after hearing from counsel for both parties on January 3rd, 2019. Now, again, we weren't parties to that proceeding, but claiming that the order was entered ex parte is not consistent with the text of the order. And with that, I'll rest unless the court has any further questions.
Okay, thank you. Ms. Moon?
Good afternoon, and may it please the court, Chloe Moon on behalf of ACS. I'd just like to mention a couple points that we haven't addressed. Specifically, that none of the evidence relied upon by the ALJ was outside of the record. The decision relied on only exhibits that were admitted at the fair hearing. State 1, Agency 1, Agency 2, and Appellant A were all admitted at the fair hearing, and those were the only documents upon which the ALJ relied in her decision, other than case law, obviously. I also want to specifically mention that the agency exhibits were provided months in advance of the fair hearing, and you can see that in an email at R316 and R317. Those are the intake reports and the progress notes that were emailed to petitioner's counsel. And they were specifically noted in the transcript that they had been provided by the ACS attorney. And the fact that petitioner's counsel only objected on the basis of hearsay really does go to the fact that they were provided to him in advance. Otherwise, he probably would have objected on those grounds. And then I just want to get to the point that the state respondents were making about hearsay being admissible in administrative proceedings, as you all have asked. There are two particular cases I just want to draw the court's attention to. One is Matter of Velez, which was a case from this department in 2018, and Matter of Parker in 2011, both of which were remarkably similar cases in terms of allowing hearsay in. Based on their allowing hearsay as admissible. They were agencies' investigatory reports, progress notes, just like here from ACS, with the mother's and the child's statements. And in both of those cases, you had petitioner's testimony that was contrary to those particular progress note evidence. And both of those, this court has found there was they supported substantial evidence. And then finally, to the order that was entered from August 2019, I just want to state that that has nothing really to do with whether or not the report is indicated, first and foremost. But second, this is kind of showing us that the process is working as it's supposed to. The report was indicated, it put everybody on alert that ER was maltreated, and that resulted in the January 3rd, 2019 modification of the visitation. And that severe restriction was only worked back up, according to this August order, on agreement of the parties. And so I think that's a really important part as well. Okay. Yes.
No.
And
good. All right. Thank you, Ms. Moon. Mr. Greenberg, you get 1 minute.
Yeah, I have so much to say, but I'll do it fast. The order was a litigated order, Your Honor. It wasn't by stipulation, and it was over the objection of the former wife and her attorney. In terms of,
but it's unrelated. I guess the point Ms. Moon was trying to make is that it's unrelated to the issues that we are under review before us.
It's related to the extent that, and it was an ex parte. As a matter of fact, at the time that Justice Katz, January 3, 2019, signed that order, the child and the ex-wife were still on vacation in Italy at the time. It was based solely on the papers, and the restoring of his
counsel, was your client getting treatment at that time, improving his parental skills? I mean, that's generally what the progression is in these cases, right? And couldn't one argue that, in fact, that's what he did? He was compliant, and the court at that point allowed more visitation because he was able to control those impulses that we all have, but we control.
I'm glad. Okay, so first of all, he wasn't treated. He did have counseling both before and after, and he acknowledged that he learned. But let me make this point, and this was alluded to, I think, by the Assistant Attorney General, that in that August 2019 order, the person who had been doing counseling had withdrawn because, and again, the order speaks for itself. But the point is that Mr. Rosengarten, at the time that Justice Katz restored his alternate weekend and holiday visitation, there was no longer a counselor in the picture. And as a matter of fact, that counselor was withdrawn for issues he had with the parties. And nevertheless, Justice Katz, based upon all the prior proceedings, after he'd heard from both sides and attorney for the child, restored Mr. Rosengarten's parenting time.
Okay, thank you.
Thank you.
Thank you, Mr. Greenberg. Thank you all.
Thank you.
Thank you, Your Honor.
This concludes oral arguments for the Appellate Division First Department of February 2nd of 2022.